thank you all so much for being here. I think we're going to get started. I'm Vic Amar, I'm the Dean of the Law School, and in the last few weeks I decided that no one is really coming to hear an introduction. So I'm going to cut to the chase. Paul Clement is our Vacketta lecturer this year. I want to thank Carl Vacketta, who is one of our most generous, one of our most dear, one of our most helpful alums, who endowed this lecture. Carl, among the other reasons I look forward to this lecture is it gives all of us a chance to see you in person again every year. So thank you so much. Let's give Carl a hand. I encourage you to read Paul Clement's bio on his card. He's one of the most accomplished, most well-respected, most sought-after lawyers in America. He's nearing his 100th U.S. Supreme Court oral argument. He's been in the private sector, the public sector. Let's just listen to Paul, and he'll take some questions afterward.
Thank you, Dean, for that concise but wonderful introduction. It does sort of get to the pith of the matter, and it's great to be with you all today. I am a Midwesterner by birth from the great state of Wisconsin. I see a Wisconsin sweatshirt out there, so I think there's at least one friendly face in the audience. And I'm just delighted to be back in the Midwest, particularly on a day that seems tailor-made for football. But an indoor lecture, it's not where it's a little warmer, isn't the worst thing either. So what I want to talk about today is really kind of two things and try to bring them together. I want to talk about the Office of the Solicitor General, an office that I was very privileged to work in for about 7 years. And then I want to talk about the Roberts Court. But I really want to talk about kind of what it's like to work in the SG's office, how that is a little bit different, but not completely different from practicing law in the private sector, and then speak a little bit about what it's like to practice law in front of the Roberts Court, both pre-Justice Kavanaugh and I think going forward. So I'll start with the work of the Solicitor General's office. I think the Solicitor General in particular is probably the greatest legal job that most people have never heard of. The Solicitor General in certain legal circles is a very big deal, but I don't think anybody in the office kids themselves to think that it is widely and generally known. When I was Solicitor General, I occasionally had to explain to people that we're not the ones that put the warning labels on cigarettes. That's the other SG, the Surgeon General. But it really is a tremendous legal job, and don't take my word for it. Just two quotes that I think are worth sharing. Justice Robert Jackson, one of the great jurists our country has ever had, and one of the greatest judicial writers our country has ever had, was both the Solicitor General and the Attorney General before he served on the court. And he himself remarked when he changed from serving as the Solicitor General to the Attorney General, he said, I quote, stepped out of the job in the executive branch that I enjoyed most and into a sea of troubles. But Justice Marshall, Thurgood Marshall, was even more emphatic. And he said flat out that being Solicitor General was the best job he ever had. And he, of course, had been Justice, Second Circuit judge, head of the NAACP Legal Defense Fund. So he'd had some great jobs, and yet he thought the Solicitor General's job took the cake. So to the extent people know anything about the Solicitor General and the Office of the Solicitor General, they know that that is the lawyer who argues cases for the executive branch of the United States in the Supreme Court of the United States. And I want to impress upon you that although that is very true, and one of the greatest honors any lawyer can have is to step up at a podium essentially and represent the United States, particularly in the Supreme Court of the United States, arguing cases in the Supreme Court is just the tip of the iceberg. One historical footnote, though, about the Solicitor General's role arguing cases for the entirety of the federal government. So it doesn't matter if the case comes up from an agency like the FCC. It doesn't matter if the case comes up through an entity that might have independent litigating authority in the lower courts. It doesn't even matter, for example, if the TVA, the Tennessee Valley Authority of all things, is represented in the United States Supreme Court by the Solicitor General. The historical explanation for this really goes all the way back to the creation of the Solicitor General's office in 1870, and it really explains the name Solicitor General. It's one of the customs of the court is that the Solicitor General is referred to by the justices as General fill in the blank. So General Francisco today, General Kagan when Justice Kagan was Solicitor General, and so on. It's sort of mystifying because general is an adjective. It distinguishes a solicitor, say, of the Treasury Department from, or the Labor Department. It is a Solicitor General, i.e. for all of the parts of the government. So calling somebody General so-and-so when general is in fact an adjective and not a noun is a bit mystifying, but there it is. But what happened in 1870, it's shocking to me, frankly, that the founders of our nation made it 100 years without a Solicitor General, but it's true. But there are many good reasons to avoid a civil war, but one thing that a civil war produces is lots of litigation. And so in the wake of the Civil War, there was all sorts of litigation involving the federal government, and there were all sorts of lawyers representing different parts of the federal government in the Supreme Court. And they were sometimes taking positions that really were diametrically opposed. So the idea of creating a single office to argue cases for all the different departments of the United States was part and parcel of the Act of 1870 that created the Justice Department. It's an interesting historical footnote that essentially every other one of the original cabinet officers that were created around the time of the framing, at the same time the cabinet officer was created, so was a department to go with it. So you had the Secretary of War and you had a War Department. But for the first 100 years, we had an Attorney General and not a Justice Department. So the same statute that created the Office of Solicitor General created the Justice Department. My personal favorite aspect of that statutory change was that for the first 100 years, the Attorney General was specified by statute as having to be learned in the law. When they created the Justice Department in 1870, that requirement that the Attorney General be learned in the law was actually moved from the Attorney General to the newly created position of Solicitor General. So for the last sort of 150 years, the Attorney General has not had to be learned in law. Some of us would suggest that at times it showed, but during that entire time, the Solicitor General has been required by statute, and I think there's only one other officer in all the government. He's been required, or she has been required by statute to be learned in the law. So that is how we created this office, that the specific purpose was to argue all of the cases for the far-flung interests of the federal government, and to do so in a way that allowed the Solicitor General to take positions that made sense across agencies. So they weren't arguing for deference in one case and against deference in the next case, but taking positions that made some kind of coherent sense. But I do want to impress upon you that although arguing cases in the Supreme Court is the most public aspect of the job, in my humble view, it's probably even the most fun part of the job, but it's just the tip of an iceberg. So the rest of the work of the Solicitor General's office is profoundly important to the federal government, and the central role that the Solicitor General does, which is probably more important than arguing the cases, is the Solicitor General is the person in the government, and this office is the entity that allows the government and authorizes the government to pursue an appeal, to pursue a Supreme Court petition if a court of the United States, an Article III court, has ruled against the government. So if you think about the Justice Department, there's 93 U.S. attorneys litigating criminal cases all over the country. There are lots of efforts to try to make sure they're not doing things that are diametrically opposed with each other, but it's a pretty kind of top-down sort of sense that, okay, here's the U.S. Attorney's Manual, here are our prosecutorial priorities, but there's a lot of autonomy in a U.S. Attorney's office for the U.S. Attorney to pick certain kinds of cases to bring, to make certain arguments. And the Justice Department tolerates a certain amount of diversity as long as the arguments are working. But at the point that the argument runs into a district court that rejects the argument, or a court of appeals majority that rejects the argument, if the U.S. attorney wants to take the case any further, if a department of the government wants to take the case any further, they need to get the approval of the Solicitor General. And so these requests for approval kick off an internal process where the department that's interested, as well as any other departments that are affected, write a series of memos. An assistant to the Solicitor General writes a comprehensive memo making a recommendation to the Solicitor General. A deputy Solicitor General annotates that memo, and ultimately the Solicitor General makes a determination based on a stack of papers about whether the United States should appeal the case or whether the United States should let the case go. And that process takes place, at least when I was Solicitor General, and I don't think the pace of this has changed radically, about 2,000 times a year, which, if you break it down, that's, roughly 6 big packets and 6 very consequential decisions that the Solicitor General has to make every day, and that would include weekends, and that counts. So it's a huge part of the work of the office, and it's a huge responsibility, because the Solicitor General, by and large, has the last word on these questions. The other thing that the Solicitor General's office does is they, as part of the work of the office in the Supreme Court, is they produce all of the petitions when a decision to try to take an adverse lower court decision to the Supreme Court. The Solicitor General's office will prepare that, all of the briefing, but they also have the ultimate sort of responsibility for filing briefs and oppositions in literally thousands of cases where somebody who has not succeeded against the federal government in litigation somewhere in the system files their own petition for certiorari. And in those cases, hundreds of cases a year, the office has to decide whether to file a brief in opposition or whether to waive their opportunity to file, and if they decide to file the brief, to prepare the brief. Two more things that are actually related that I will mention is that the office is also responsible for determining the position of the United States as an amicus and responding to invitations for the views of the Solicitor General. The latter is an interesting phenomenon. When you file a cert petition in the Supreme Court, you generally think of there being 2 possible answers. The overwhelmingly large percentage of the time when you file a petition for certiorari in the Supreme Court says no, cert denied. About these days, 75 times a year, the court will grant your case and then have full briefing and argument on the case. But about 24 times each year, something else happens, which is there is a formal invitation from the court to the Solicitor General to file a brief that reflects the views of the United States. Now, this is certainly a proverbial invitation that one cannot refuse, so it's a formality that it is an invitation, but it is a request to file the position of the United States in a private party case that the United States has not participated in previously. And I'll talk just for a second about that process because I think it's quite interesting. And it's the same basic process that happens if the court grants a case that doesn't involve the federal government, but without soliciting the views of the United States. There's a similar process to decide whether the United States will participate as an amicus curiae. And when either an invitation or the grant of a case, the office will send out essentially a notice of the case to all of the various parts of the federal government who might have an interest in the case and solicit their views on what position the United States should take. Now, sometimes that's a pretty straightforward process. If a lower court, for example, has invalidated a banking regulation, then the banking regulators within the government, and there's more than one just to keep it complicated, so the comptroller of the currency and the Treasury Department, and maybe somebody else would weigh in, but it's the affected agencies in that case would weigh in. If a regulation has been struck down on, let's say, APA grounds, then it's going to be a pretty straightforward process to say that the interest of the United States is to support the validity of the regulation and support that side of the case. The office will also opine whether the case is worth the court's attention, and sometimes that's a closer question. But some cases are easy. The cases, though, that are in a sense more fascinating are the ones where after the Solicitor General's office solicits the views of various entities within the government, they get varying opinions about what the office should do. A classic case of this is a case that arises, and this happens quite a bit, is you could have a case involving an anti-discrimination statute that applies to private sector employers. So think of Title VII, think of the Americans with Disabilities Act. That case goes up to the Supreme Court. Most of those anti-discrimination statutes are applicable in one form or another to the federal government as employer. And the Civil Division of the Justice Department is responsible for defending the United States as employer against anti-discrimination claims. So in a typical case, the SG will hear from the Civil Division. The Civil Division will say, oh, this is important to the interests of the United States, and we need to favor the employer because, after all, the United States government is the nation's largest employer. So we have a huge stake on the employer side of this dispute. Okay, but the Solicitor General is also likely to hear from the Civil Rights Division, and the Civil Rights Division is responsible for enforcing many of those same anti-discrimination statutes, particularly against state and local governments, but more broadly, they have an enforcement authority, so they may weigh in, quite likely, on the employee's side of the case. The EEOC may weigh in on the employee's side of the case as well. The Labor Department may have a view on this as well. So before it's all over, the Solicitor General has recommendations from 4 or 5 different parts of the federal government to do things that are not actually consistent with each other and are indeed mutually exclusive. And the Solicitor General at that point has to essentially convey an internal process to come up with a decided view of the United States on the matter. And it is, I think, can be quite contentious internally. I think there are certainly efforts to make those decisions prudently, and oftentimes one of the agencies may have their position embodied in a regulation that's entitled to deference. The competing view may be just a view that was created for purposes of this particular piece of litigation, and so maybe the office ultimately sides with the agency that has a view that's reflected in a regulation. Sometimes there are interests on both sides, but the legal position on one side is much stronger, and the department decides, the Solicitor General decides to file the brief on that side. But in the vast majority of these cases, and this process is kicked off at least 50 times a year in Supreme Court cases, the stakes can be quite high, and in the Solicitor General will most often have the final word on the matter. I'll say one more thing about that, though, in terms of the structure of the office. One other thing I want to highlight is that the Solicitor General's office reflects a certain model of approaching Supreme Court litigation. And the model is very much that the United States government is going to use appellate experts and not subject matter experts. I mean, if you think about all of the resources that the federal government has at its disposal when one of its cases that it cares deeply about goes all the way to the Supreme Court, the federal government would certainly have somebody at its disposal, a lawyer in one of the affected departments, that knows as much about the subject matter as anybody else on the planet. And it would be a perfectly rational judgment, I suppose, to have that expert argue the case. You can see that the decision to have the expert argue the case would be a little bit at odds with the whole theory of the formation of the office in 1870. And really, since the very beginning, the judgment has been, let's get input from the expert, but let's have an appellate specialist, somebody who's in front of the court on a repeated basis, be the one that makes the argument for the United States government to the Supreme Court. That model is very much embedded into the office. I am a big fan of that model, and just to give you a sense of how that can work in practice, it really can work quite well. And maybe one subtle reason why it does make sense, in my view, to have the appellate expert rather than the subject matter expert argue the case is that by the time the case gets to the Supreme Court, and in particular, by the time the 9 justices are looking at it, even if it's a very important issue to those in that particular area of law, the justices aren't really looking at it that way. And at the end of the day, the 9 justices are themselves generalists. You know, they are not specialists in tax. They are not specialists in environmental law. They hear everything. And I think it does make a lot of sense to have a generalist appellate advocate making the argument to a generalist Supreme Court. In a sense, you're speaking the same language. And sometimes the case that from the specialist perspective is really about something different from the way that the Supreme Court processes it. So the example I would use is a case I argued when I was in the Solicitor General's office called Rapanos, and it was a case about the jurisdictional reach of the Clean Water Act. And essentially, the Clean Water Act gives the federal government authority over the navigable waters in the United States, but with respect to non-navigable waters, the statute leaves that to state and local governments. So it leads to some obvious questions about what constitutes a navigable waterway. Now, when I first picked up the briefs in this case, I had no idea. Hadn't really thought about the question, would never even suggest that I'm any kind of environmental law specialist. But after several meetings and ultimately several moot courts where we had the benefit of interacting with the lawyers from EPA and the Army Corps of Engineers, who had great subject matter expertise in this, we were able to formulate a position that I think was responsive to where the Supreme Court was coming from. And there was one lawyer in particular, his name's Lance Wood, in the Army Corps of Engineers, who knew more about this statute and the regulatory history of this statute than any person on the planet. And he could answer any question in the context of moot courts about the statute. Now, it was tempting to send Lance up to argue the case, but I don't think it would have been the right answer, because from the justice's perspective, this really wasn't about sort of environmental law or efficient regulation of sort of the issues, the dredge and fill permits that the Army Corps of Engineers cares about. It was a case about federalism. It was all about where does the power of the federal government extend to and where does it leave off and what's left for the states. And if the federal government's right in this position, in this case, what's left for the states. So Lance would not have been the right person to argue the case, but boy was he the right person to have in the moot courts. And one exchange that we had in the moot courts, and moot courts are an important part of the preparation process in the Office of Solicitor General, there were questions, skeptical questions about, well, isn't the position the United States is taking in this case, like, doesn't it extend to like ditches and culverts and all sorts of things that don't feel like free-flowing bodies of water, like the Chicago River, the Mississippi River. And in the after discussion, Lance pointed out that it would make no sense whatsoever to draw a distinction between man-made sort of ditches and things like that and natural flowing rivers, because in fact, almost every naturally occurring river that has been used for commerce has been channelized over time, and sometimes the flows of the river have nothing to do with their natural flows. But even more to the point, some of the most classically navigable waterways in the United States are, from a definitional perspective, ditches, with the best example being the Erie Canal. As a technical matter, the Erie Canal is just one big ditch. So fast forward to the oral argument in the Supreme Court, within I'd say 2 seconds, but at least 2 minutes of stepping up, Justice Scalia was all over me, saying, your position's ridiculous, you'd regulate ditches and culverts. I mean, wouldn't your position extend to ditches? And thanks to Lance, I was in a position to say, absolutely, Your Honor, but the Erie Canal's a ditch. So if we're going to regulate the navigable waterways, we could hardly exclude ditches if the Erie Canal's a ditch. And he left me alone for a good 10 minutes after that. Now, he eventually got back, but he had to think about that for a while. And that sort of shows that, let's say, again, Lance wouldn't have been the right person to argue the case because he wasn't thinking about the issue entirely through a federalism lens, which was the way that the court was thinking about it. But he had the expertise that we could tap into. So that's the OSG model in a nutshell. And the last thing I'll say before talking a little bit about litigating in front of the Supreme Court in private practice is to talk about the 10th Justice puzzle. Some of you may have heard the Solicitor General referred to as the 10th Justice. What that betokens is the closeness of the relationship of the Solicitor General and the office with the 9 real justices, as I like to call them. And it also sort of suggests that there is a degree of independence that the Solicitor General enjoys from some of the rest of the executive branch. Now, one of my predecessors as Solicitor General, I think probably captured this a little better by saying that, it's not really the 10th Justice, none of the 9 real justices have ever referred to the Solicitor General that way. The 37th law clerk might be a little bit closer to the truth. But there is something to this idea that the Solicitor General has a freedom to take positions in the long-term interest of the federal government and has a degree of independence one wouldn't expect from what is, sad to say, at bottom, a sub-cabinet officer. And so I think it's worth thinking about this a little bit, because the answer to this kind of idea of there being a degree of independence with the Solicitor General, the answer certainly does not lie in the organizational chart, because the organizational chart is entirely straightforward. The Solicitor General works for the Attorney General, who works for the President. So on any given case, either the Attorney General or the President could essentially dictate the position that the Solicitor General should take in that particular case. And as a matter of sort of executive power, Article 2, where the authority of the Solicitor General comes from and the like, there would really be no basis for a Solicitor General to argue that the President or the Attorney General cannot do it. Plenty of room to argue that you should not do it, but there's no room to argue that you cannot do it. Yet, I think if any Solicitor General got in the situation where that was happening with any frequency, I think they'd be well advised to resign. And in practice, that's not the way that the office operates. So what explains if it's not the org chart? I think there are three sources of this kind of unique relationship between the office of the court. Call it the three U's, because they each start with a U. One is the Solicitor General enjoys a unique position in the separation of powers. And I think you can see this in a very physical way, which is the Solicitor General actually has an office both in the Justice Department, but also has a mostly ceremonial office, but an office in the Supreme Court of the United States. So it's an office that the Solicitor General and the office can use before their arguments, and it really is their office at the court. And the only other sort of officer that I know of that has a formal office in two branches of government is the Vice President, who has an office in the Senate as well as in the White House. So that gives you a physical manifestation of this unique role, but I think the practical manifestation of it is actually more important. And the reason there is this unique role is because the Solicitor General is up there in front of the Supreme Court, constantly interacting with the Supreme Court, and at the same time, there is a deep-standing tradition in the office that the government will, and the Solicitor General's office in particular, will offer arguments in defense of the constitutionality of statutes as long as a reasonable argument can be made. So even a statute that the current administration might think is a policy abomination will still be vigorously defended by the Solicitor General's office and the Solicitor General appointed by that president. So that's part of where this role comes from. The second U, and I'm cheating because I'm going to use unique again, but the Solicitor General is in a unique position vis-a-vis his or her clients. And to me, this is very obvious, and it's a very obvious difference from the private sector context. But the Solicitor General is the monopoly supplier of legal services to the rest of the federal government in the Supreme Court. So in private practice, if you have a client who comes in and says, we just lost a big case, I'd like to take it up to the Supreme Court and file a cert petition, your reaction in private practice is, that's awesome, let's go. And that's in part because it's good for business, and in part because to a moral certainty that if you said, well, actually I've looked at this and I don't think this is really the right time for us to take this particular issue up to the Supreme Court, they'd say, thank you very much, Paul. I got about 6 other names I can call, and I'm going to get started on that process right away. But it doesn't work that way. So if the Treasury Department has some long-standing policy that's been invalidated because it's inconsistent with a constitutional provision or the APA, they don't demand, they ask the Solicitor General to take the case up to the Supreme Court. And the Solicitor General may decide that, we'd have to take a position in defending this regulation that's inconsistent with a position we need to take in other cases, and we're not going to do it. And the Secretary of Treasury doesn't have to like that decision. And in theory, they can try to call somebody at the White House or the Attorney General. But in practice, the Solicitor General's decision not to take the case up sticks. And that creates a dynamic where the Solicitor General is able to both have some independence from the rest of the executive branch, but also garner some credibility with the court because they're not up there taking any position that a client wants them to. They're taking positions effectively that they've vetted themselves and are in a position to advance positions that make the most sense. Sometimes this can work even in the other direction, and I'll just give you an anecdote from my time in the government, which was fairly unusual but fairly interesting, which is there's a case called FEC against Beaumont. And in this case, the Fourth Circuit had struck down a campaign finance statute as inconsistent with the First Amendment. And it was in the context of an enforcement action brought by the FEC. But the FEC, during a Republican administration, looked at that and said, the Fourth Circuit's probably right. This statute is, kind of dubious constitutionality, so we're not going to file a cert petition. We filed one anyways, in their name, because an act of Congress had been struck down as unconstitutional. So we litigated a case in the Supreme Court, essentially over the objection of our client, because the client's part of the United States and we represent them in the Supreme Court of the United States. So that is not a dynamic you're likely to have in the private sector, to be sure. But I think actually, and just to tell the rest of the story, we won 7-2. So, this wasn't like a particularly close case, and I think we gained a lot of credibility with the court, because none of this was disclosed to the court. Because there was a public vote of the FEC not to go forward. So we disclosed this all to the court. The other side objected and said, this is somehow ultra-virus. The court knew all of that, knew that we'd essentially taken this case to defend the constitutionality of an act of Congress to the court over the objection of the agency, and I think it stood us in very good stead with the court over time. So there's that unique position. The last view, though, is that the Solicitor General is the ultimate repeat player in the Supreme Court. The Supreme Court has about 75 cases a year. The Solicitor General's office is up there in like 60 of those cases, and sometimes as a party, sometimes as an amicus. So there's just very little temptation as a lawyer for the Solicitor General's office to try to take a shortcut, to try to take a position that's expedient for this case, but is going to come back to haunt you in another case. And there's very little temptation to do anything that could possibly undermine your credibility with the court, because if you undermine your credibility in this case for this government client, you're going to be back there in a month or two for another government client. And so by being a repeat player, you're really in a position where you have to treasure your relationship with the court because you're going to be back there so many times. So let me just contrast this briefly with the idea of lawyering in the private sector. As a former Solicitor General, I think I speak for almost every former Solicitor General in saying that the first thing you do when you leave the office, if you stay practicing law and don't become a justice like General Kagan, the first thing you do is try to replicate the office of the Solicitor General as much as you can in your private law firm. So you try to hire really, really smart people who are going to focus on the Supreme Court and the Court of Appeals practice. And that's certainly what I've done, and that's certainly what others have done before me. So I think that's certainly something that you try to do. But I think you realize that you cannot replicate the unique position that the Solicitor General has in the separation of powers, nor the unique position that the Solicitor General has vis-a-vis the clients. When a client calls with a position, and I might think to myself, certainly there are extreme positions where you're not going to file a petition because it's meritless or dead on arrival, but if they call with a petition where you think it might have a chance, it really might be better for the defendants in these kind of cases as a general matter to wait for a better vehicle, I don't worry too much about that, though, in the private sector. That's just not a practical position to take. But at the same time, and I think this is more true today than it's probably ever been in the Supreme Court practice, as an outside lawyer in the government, a lawyer outside the government, but as somebody who is a member of the Supreme Court bar, you're still very much a repeat player. You're not there quite as often, though you'd like to be and you try. You're not there quite as often, and you're not there for the same basic client. But you are there a lot. And you do, I think, value your credibility with the court to a very, very high degree, such that, speaking for myself, but I think for almost every member of the Supreme Court bar, you're just not going to take a position that is expedient for one client at the expense of your credibility in order to win that one case. Because you want to win that case, but you want to be back there for another client in a couple of months and win that case too. And the surest way to undermine your credibility with the court and your ability to represent both clients effectively is to say something to the court that distorts the record or shades things in a way that's inappropriate and undermines your credibility. So I think that is something that I think does carry over very much. I'd say two things about this. One, I'll finish with an example of this, but I'll also just say that I think in many respects, the way that the Supreme Court bar behaves and conducts itself is something of a model for others in the profession. I think it's not quite maybe the universal rule, but there's something to be said for behaving in every court as if you're litigating in a court that you are going to be a frequent repeat player in. So I argue appellate cases all over the country. I may argue a case in a state Supreme Court where I'm unlikely to get back anytime soon. But I think I always try to conduct myself the same way in those courts as I would in front of the Supreme Court, where I'm pretty sure I'm going to be back and all the justices are going to be the same and know exactly how I behaved in a prior case. So I do think, in some respects, both the Solicitor General's office, to be sure, but even the private Supreme Court bar is a model for the profession. I'll say this just by way of example. I have a case which was a happy occasion to get to know Professor Brubaker this last term called FTI, and it shows, I think, a couple of things about what it's like to argue in front of the Supreme Court in the private sector. First, it can be a lot of fun, and I think you still have this sort of special relationship with the court where you really are legitimately trying to help them. Trying to help them see their way to ruling for your client, to be sure, but you're trying to help them and trying to essentially be an officer of the court. And that was front and center in the case that we had because there was more than one way for the court to rule in favor of our client. And it was, part of the argument was really spent trying to steer the court to one way to rule for our client that was a little bit different from what the lower court had ruled, but we actually thought was the better way for the court to decide the case. And in making that kind of argument, you really do feel like you're an officer of the court. The other thing that was kind of interesting about this case is it does show that even in the private practice of law, there's a role for both generalists and specialists. The issue in this case, without sort of getting too much in the details, had to do with whether certain transactions in bankruptcy that a trustee could make were avoidable transactions, or whether certain transactions were avoidable by the trustee, or whether they came in an exception to the trustee's avoidance power. And a number of lower courts had accepted a quite broad position that essentially any transaction in the securities context that went through a financial institution was in fact something that could not be avoided. And that really didn't make a lot of sense, and it did not seem what Congress was trying to do. But a number of lower courts had ruled that way, and a number of lawyers had argued against that position, essentially trying to say, well, the text of the statute's a problem, but we're going to tell you some other reasons why you should rule in our favor. Now, that seemed to us, as generalists, to be kind of a suicide mission in the Supreme Court right now, to say, well, the text isn't so good for us, but let me tell you about something else. So we really wanted to refocus the argument in a way that focused on the text and showed that the text was helpful for us. And we thought we'd come up with a pretty good way to do this, but we don't really know anything about bankruptcy. And at about the time we were thinking through this, Professor Brubaker came up with a very thorough article that essentially came out in the same place. And it was a very, very happy marriage because he knew what he was talking about, and we knew what would sell in the Supreme Court of the United States. Taking liberal use of his article and inviting him to file an amicus brief, which he did, we took that position to the United States Supreme Court. I think I was able to argue the case in a way that satisfied the Supreme Court that this did make a lot of sense, that it was the right way to decide the case. We ended up winning the case unanimously, even though the lower courts had relatively lopsided ruled the other way. And I think it really was the combination of an argument that spoke to them, because they don't really view this as a bankruptcy case. They view it as a statutory construction case, and it was a way for them to, in a way that still honored the text, to come out in a way that made more policy sense. But I think it really helped them to know, thanks to Professor Brubaker, that it also made bankruptcy policy sense, and this actually did work for those that actually understood the field in a way that I didn't, and the justices, frankly, don't. So it does show that that idea that, it may make sense to have an appellate expert argue the case, but it also makes sense for a subject matter expert to sort of have your back. I think that's true in the SG's office, and it's also true in the private sector. So I'm just going to say just a few words about lawyering in front of the Roberts Court, and then I'll save some time for some questions. So all of these, similarities and differences between being in the SG's office and being in private practice, come to the fore in terms of trying to argue cases in front of the Roberts Court. The Roberts Court is an interesting sort of court in the sense that you have three different alumni of the Solicitor General's office. You have a Justice Kagan, a former Solicitor General. You have Chief Justice Roberts, a former Deputy Solicitor General, and you have Justice Alito, who's a former assistant to the Solicitor General. You now even have in Justice Kavanaugh a former Bristow Fellow, which is a one-year internship in the Solicitor General's office. So literally every lawyer position in the Solicitor General's office is represented on the Supreme Court. So these are justices that know a lot about the Solicitor General's office and a lot about arguing cases, but they're also among the most active justices in history in terms of the number of questions they ask. Just as an anecdotal demonstration of this, a few years ago, a friend of mine in the Solicitor General's office argued a case. I think it actually was a tax case. So this is not something that was front page news, but it was an important tax case. He thought the court was particularly active in his case. So he actually took the trouble, which I thought about doing but never actually did. He took the trouble of counting up how many questions he was asked in a 30-minute argument. And the number he came up with was 77. So a little more than 2 a minute. Now that is what I would call a live bench. And so the art of arguing in front of the Roberts Court, whether you're in the SG's office in private practice, is the art of answering questions. It's not about having this brilliant thought out in advance, 5-minute oration, where you are just going to persuade the court based on the beauty of your words. It is all about answering questions, and it's all about answering questions incredibly concisely. One way to think about the dynamic that really, I think, differentiates it from arguing a case in the Court of Appeals is in a typical Court of Appeals argument, Federal Court of Appeals argument, you have three judges asking questions, and in most places, the presiding judge is pretty mellow about the red light. So if one of their colleagues, they're not going to let the lawyer talk on and on, but if one of their colleagues has additional questions, they'll continue to let the questions flow. And so as a result, there's not a lot of pressure on the judges to interrupt an advocate with another question when they're still being responsive to one of their colleagues' questions. It would be kind of impolite. In the Supreme Court, by contrast, you have, Justice Thomas has been historically reticent to ask a lot of questions, but you have 8 justices asking lots of questions in a context where the Chief Justice actually does care about the red light. And so that puts incredible pressure on the justices themselves to not give you a lot of time to answer the questions from their colleagues before they come with the follow-up question. So in order to be effective on behalf of your client in front of this court, you have to be incredibly concise in answering your question. So the last thing, there's much more I could say about the Roberts Court, but what I'll say is, I do think in light of recent events, the Roberts Court is at a very kind of delicate pass. Whatever you think about the nominations process and whether the Senate Judiciary Committee and the Senate got it right in the end or wrong in the end, I don't think any of the justices looked at that confirmation process and said, this is good for the court. I think all of them understand that that process was a very bad dynamic for the court and the perception of the court in the public eye. And my sort of the most obvious evidence for that is when there was the swearing-in ceremony at the White House. All 8 justices went and attended that ceremony. Now, I'm going to go on a limb and say that Justice Ginsburg, for example, probably had places she'd rather be than the Trump White House on that particular Monday night. But nonetheless, she and every one of her colleagues went there, I think, as a sign, as a sign of solidarity and as a sign that sort of business goes on. And I think the next morning, when the court heard the first cases on which Justice Kavanaugh sat, I think there was a concerted effort by all of the justices to sort of get on with business as normal and show that the court is going to conduct its business in a certain way. But I do think this is a real challenge for the court. I think probably every one of the justices probably recognizes that 5-4 decisions in high-profile cases are a problem for the court, especially if that gets to be a recurring pattern where it's the same 5 and the same 4, and it just so happens that the 5 were appointed by presidents of one party and the 4 were presidents of another party. But although I think all 9 would agree that that's a difficult and problematic dynamic, I'm not sure any of the 9 are going to cast their vote differently in the cases they care most about, nor am I really sure they should. But I think the court is going to have to look for ways to nonetheless kind of move forward in a way that reinforces the fact that the court is not that closely divided. I have a suggestion. It's self-serving as a Supreme Court lawyer, so I'm a little bit embarrassed to say it, but I actually think in all seriousness that it would be helpful, which is I think the court should take more cases. And I think they should consciously take some cases. I mean, and I think this goes back to the time that we were law clerks. I mean, the court historically doesn't like to take cases for what the law clerks call error correction. They want to only take cases because there's been a divide on major issues where 3 circuits have gone one way and 3 circuits have gone the other. But the problem with cases where the circuits have gone different ways is they're likely to pull the justices in different ways. And there are plenty of cases, not just in cases where I'm writing the petition, where the lower court in a case of considerable consequence has just gotten it wrong and gotten it pretty obviously wrong. And if the court took a few more of those cases, they would be unanimous more often. And I mean, I guess, so a long way of putting this, or a short way of putting this is, I'm not sure they can do much about the denominator of cases where they split 5-4, but they can do something about the numerator. They can do something about having more cases where they are actually unanimous or close to unanimous. And I think that's something that would actually help the court in the long run. So I'll end there on a self-serving note that the court, gosh darn it, should take more cases from both the SG's office and the private bar, and that'll move things in the right direction. So thank you very much.